Hi, I'm Greg Hunt and welcome to No Disputing That. I created this podcast to give you an in-depth look into the world of mediation and arbitration. Each episode I'll be having a conversation with one of the most renowned names in the field, plus some you may not have heard of yet. We'll cover a wide range of topics from ADR to other areas of the law and life in general. So get ready for a unique blend of thought-provoking discussions, plenty of laughter and occasional audio slip-ups. Welcome to episode 13 of No Disputing That. Today I speak with Remy Gerbay. Remy is first and foremost a proud Stéphanois, which means he is a native of the glorious city of Saint-Étienne in France, which he says is the undisputed football capital of France. Remy is a partner in Hughes, Hubbard and Reed's arbitration group in Washington and often sits as an arbitrator. He is director of an LLM program in arbitration at Queen Mary University of London. Prior to moving to the US 6 years ago, Remy worked in London for 12 years. He trained as a solicitor and worked in the arbitration group of Herbert Smith before joining the LCIA, where he occupied various positions including senior counsel and deputy registrar. He has two children, aged 6 and 4, who are half American and half Stéphanois. Allez Saint-Étienne. Hi, how are you?
Very good, yourself?
Good, yes, not too bad, thank you. Yeah, really good. You at home?
No, I'm working from the office today. We're very much back at the office now.
Oh, yeah. Yeah. I think people are getting slowly back to the office now. There's still quite a few people over here who are sort of hybrid, most of the time at home, but largely getting back to the office as much as possible.
Makes sense.
Yeah. You're in Washington, aren't you?
I'm in Washington, yes, that's right.
And for listeners in the UK, that isn't a little town just outside Sunderland. Remy is actually in Washington in the US. I think last time we met each other, we were probably in the IDRC in London, which was at the time on Fleet Street.
That's right, 17th Fleet Street. I remember discussions about football in particular.
Well, you know, something that has come up today, which I didn't know before, is that you are, now I might pronounce this wrong, but you are a Stéphanois. Is that right?
That's right, yes, Stéphanois.
Stéphanois, which means that you support Saint-Étienne.
Yes, Saint-Étienne football club, very much so. And if I remember, you're a Liverpool fan.
I am indeed, yeah. And do you know that one of the most famous games that Liverpool fans always talk about was the 1977 European Cup quarter-final?
Of course,
Liverpool,
for full disclosure, the game was played a couple of years before I was born, so I can't really say I remember it vividly, but it's very much part of the legend of my club as well, Saint-Étienne.
Yeah.
We actually, you'll be able to see that on your screen, but on my book on the history of the stadium of Saint-Étienne, they do have a couple of pictures dedicated to the game. Of course, focusing on the first leg, which was won by Saint-Étienne 1-0 at home. Important game because by way of context, I think so. Saint-Étienne had reached the final of the European Cup the year before in 1976, only to be defeated by the great Bayern Munich. And so in '77, Liverpool, I think, and Saint-Étienne were expected to perhaps challenge Munich for the top honors in the championship, in the European Cup, and so that quarterfinal was a big game and one which apparently saw a huge influx of Stéphanois fans coming to Anfield Road, flying over. I heard thousands of people who could not get to the stadium because they barricaded the entrance.
Yeah, and of course, well, for anyone who doesn't know, it was a famous night in Liverpool history as well. It was. We were a goal down after the first leg, and we had to win by 2 clear goals, the away goal rule. And it was 3-1 in the end, and a famous goal scored by our super sub David Fairclough. But it was a great night. And I actually watched the highlights earlier, and because I was only 7, so my brother was there, and his friends, and my granddad was there, and they talked about it for years. but I was just a little bit too young.
And you probably don't know that, but Liverpool kept poisoning Saint Etienne many years later, because 20 years after the game, John Toshak, who was playing for Liverpool in '77, became the manager of Saint Etienne and did a terrible job. Terrible job. So it was the gift that keeps giving, if you want.
Yeah, I think there are ties between the clubs now, even based on that night.
Mm-hmm.
And just to round it off, you mentioned Bayern Munich. In the semi-final, Liverpool actually played Bayern Munich and won, and then went on to win the final against Borussia Mönchengladbach, and that was our first European Cup. So certainly good memories. But when I was watching the match, on the highlights earlier, it was amazing things like Ray Clements in our goal didn't have any gloves on. You could pass back to the goalie. The goalies could bounce the ball and keep hold of it. And fouls, some of the fouls that were going in, the referee was just saying, play on. By today's standards, they would have been red cards and banned for 6 months. But back then, they didn't even give a free kick.
That's interesting. It's the reverse of arbitration then, which was people say much more polished in its practice back in the days, and now we have guerrilla tactics and all sorts of things that people didn't dare doing back in the days. So two different trajectories for football and arbitration.
Yeah, definitely. Although, so you spent obviously time at the LCIA. You wrote your PhD thesis on arbitral institutions, which was called the function of arbitral institutions. As you know, I spent 13 years at the Chartered Institute of Arbitrators as well, so I've got some experience in that sort of environment. But I'd be interested in much less detail than in your thesis. What exactly do you do in an arbitral institution in the sort of role that you had? And why would a young lawyer want to spend time working in one?
So the second question is easier to answer. I think as a young lawyer, spending time at the secretariat of an arbitral institution is sort of like doing a master's degree in arbitration, right? In a very short period of time, you're going to learn a huge amount about how arbitration works in practice. And that's because you're at the center of it. You know, you're interacting with arbitrators, interacting with parties' counsel, trying to fix problems, doing a lot of firefighting. But arbitral institutions do a lot more in arbitral proceedings than people often realize. Of course, arbitral institutions appoint arbitrators, they decide challenges to arbitrators. But what people tend to forget is that throughout the course of an arbitration, arbitral institutions are going to be called upon to make decisions in accordance with the applicable arbitration rules. And these decisions sometimes are going to shape the proceedings in a way that we don't often want to accept as arbitration lawyers, in the arbitration community. And it's something I thought was fascinating when I joined the LCIA. I thought there was a bit of a disconnect between the way that we collectively represented the role of these arbitral institutions, which was to just administer proceedings and provide just logistical support to the arbitrators who themselves would decide the disputes, and the reality, which was that institutions, in fact, took all sorts of decisions which could sometimes impact the outcome of cases. And I thought it was fascinating because that disconnect was quite clear if you look at all of the literature about the ICC, the LCIA, all of these institutions. You will see that we, as an arbitration community, routinely say that arbitration institutions are just administrators, that the entirety of the adjudicative mission is reserved to the arbitrators, that there's no decision-making that takes place there, which of course is not true. And I've always thought it was fascinating, and that's why as a young lawyer at the LCIA, I decided to do my PhD on this, because it seemed to be a bit like a myth in the proper sense of the term, a story that a society keeps telling, even though we know the story is not true, but we keep retelling the story because it conveys, because it serves a certain purpose for society. And in arbitration, to be a bit more precise, the reason why we keep saying that arbitral institutions are just administrators that don't decide disputes, which are instead decided by the arbitrators, is because the problem is what happens if we start to face the truth and say that all of these institutions are massively impacting the process. All of a sudden, you open a Pandora box with of questions like, does it mean arbitral institutions have got to give, equal time to both parties to present their case before making a decision on what it is, whatever it is, the institutions deciding, or do institutions need to give written decisions and things like that, or do domestic courts need to review these decisions like they review awards sometimes? So nobody wants this to happen when users of arbitration are complaining, and rightly so, about costs and duration of arbitration as opposed to mediation. And they, so nobody wants to look into it. So we've got this myth, which we all know as a community, as an epistemic community, if you want. We know that it's wrong. We know it's completely false. Arbitral institutions definitely decide part of the disputes, but we all sort of like a retell that myth, that story, because it serves a purpose, a useful purpose for our society.
It's really interesting. I think it opened my eyes because I'd been at the Chartered Institute of Arbitrators for probably 7 or 8 years, and actually ran the arbitration department. So was in charge of sort of all the arbitrations that were going through. And then I got invited to the ICC to see how they do things there. And it really blew me away because literally at the CIR, all we did was appoint. That was it. We get the application in. It was mainly domestic UK disputes, and sole arbitrator disputes, and you would literally appoint the arbitrator and then just hand it over, and the arbitrator did everything else, and you didn't really get involved in anything unless maybe the publication of the award, and then dealing with any complaints that came out of it, but nothing else to do with the arbitration. And then I was aware of the sort of prices that the ICC and others were charging for arbitration, but I didn't understand what the difference was. And then I went to see them in Paris, and it blew my mind. Everything that you just said is absolutely 100% true. It's such a different beast, and the level of work. And I always remember one particular thing, and it really surprised me because part of my role as an administrator of arbitration was that we couldn't fetter the outcome. That was very specific within the rules. We could ask questions and clarify questions to the arbitrator and communicate them back to the parties, but we couldn't do anything that could change the award. And at the ICC, they had teams of people scrutinizing awards before they went out to make sure that everything was right in them and that they had the authority to then make changes. And that was just something that really surprised me because that was alien to what we were doing and what I understood as the whole ethos behind arbitration.
Exactly. And I think you're putting your finger on something really important when we talk about arbitral institutions, and that is that there's a spectrum of arbitral institutions. On one side of the spectrum, you've got organizations that have a very limited involvement in the proceedings. They appoint arbitrators. Sometimes they decide challenges. On the other side of the spectrum, and in fact, beyond what the ICC does, if you go east and you start looking at arbitral institutions that trace their roots back to the old Soviet chambers of trade, then you have institutions on that side of the spectrum that are heavily involved in the proceedings because arbitration was seen completely differently. It was arbitral institutions were part of the state apparatus, before the end of the Cold War, and so the Chinese and Russian institutions in particular would be much more involved in the proceedings with rapporteurs, for example, at ICAC, the Moscow institution, that would sit in deliberations with the arbitrators, and take notes and have an influence on the outcome of the case in a way that's completely different from what the Chartered Institute, of course, would do on the other side of the spectrum.
Yeah, and that sort of belies the whole, again, myth, I suppose, that it's the same and standard and consistent wherever it is.
Exactly.
It's just clearly not. Yeah, and then there's other things like in the UK, most arbitrators are professionals first; they're not lawyers.
Right.
They're appointed because they're a specialist in a particular field, and that's what the dispute's about. Whereas you go into other countries, and in some places, the arbitrator has to be a lawyer. legally. Has to be a lawyer. So there are all sorts of differences, and it's really interesting to hear what some of them are. How did you end up in that role at the LCIA?
So I was a junior lawyer at Herbert Smith, the firm now known as Herbert Smith Freehills. I had trained in London, and I had qualified in the arbitration group. And the LCIA had a tradition of taking on secondees from the city firms to fill gaps, I think, when they had too much work. And so I was seconded by by Herbert Smith to the LCIA for a few months. And then what happened is in 2008, the financial crisis hit, and all of a sudden there was a doubling in the number of cases registered at the institution. And the institution was already very much stretched. There was not enough staff to handle all of the cases. So when the doubling of the caseload happened, there was really an urgent need for more people. And so at the end of my secondment, I went back to Herbert Smith, and about 6 months later, I think I was sort of poached, or I was willingly moved to the secretariat, because I had learned so much. I was really learning a lot. It was like going back to school, and learning about a topic that I thought was really fascinating, international arbitration.
Yeah,
But what I think, if I remember correctly, what we saw at the LCIA was there was a clear increase, a doubling in the number of cases registered with the LCIA. But at the same time, a lot of the cases would end up either settling or being withdrawn by the claimant, often because they lack the funds to actually pay for the arbitration. So you had a lot of parties that would initiate proceedings thinking they could perhaps try to force the other side to the settlement table, and sometimes they could, and sometimes they couldn't, but they lacked the funds, or they decided not to put good money after bad, and so there was a lot of stop and go at the time. I'm wondering if we're going to see
tactical, I suppose, as well. Yeah. Just another potential tactic to try and draw the other party to negotiate. Potentially too. That's really interesting. It'd be interesting to see what happens now. And particularly on the international side, because there's obviously so much conflict outside of the normal use of the word, and sort of international conflict going on as well, which clearly affects what happens in terms of arbitration. One of the things I wanted to just touch on as well is, obviously you did your thesis. Would you call yourself an academic?
I don't know. I think I'm partly an academic. Yes, I have this permanent academic post at Queen Mary, but I'm the bulk of my work is in the law firm. I'm a partner in a firm, so the bulk of my work is counsel work. And then after that, I sit as an arbitrator, and then once a week I lecture.
Yeah. So do you think that's a good thing, keeping that balance between academia and being a practicing lawyer?
I think so. I mean, it clearly has pros and cons. Personally, I think I wouldn't have it any other way. I'm really interested in the academic side of things. I love to practice arbitration, but I think I wouldn't be very happy if all I did was doing cases for clients and sitting as an arbitrator. I like to have this excuse to try to step back for a second and look at the world of arbitration and write articles and books and try to teach it. But I think I do it also because I think it makes you a better lawyer. I think if you have to stand in front of 200 students to explain to them what is the theory of arbitration, the autonomous theory of arbitration according to Emmanuel Gaillard or Jan Paulson, you've got to understand it in the first place. So it forces you to do a bit of work regularly. So that's very helpful. Now, I think that the cons is that it's not necessarily very well perceived to be doing both. And to use a French expression, you've got your bottom in between two seats. Because if you talk to academics, in particular North American academics, that they often see you as a practitioner. They'll say, okay, that person's not dedicated to research on theoretical issues like we academics are. And then you talk to law firm partners, and often they view academics with a bit of suspicion. They're overly theoretical. They are,
Yeah.
and I don't think it's something you have in the civil law world or in continental Europe or Asia or Africa, where being a law professor is perceived as being something that's good. So sometimes people will trust you more and appoint you as arbitrator or instruct you as counsel, but in the common law world, I think in England and in America even more so, it's actually it's tough. You've got your bottom in between two seats.
Yeah. No, it's I don't see myself as an academic at all. I do teach mediation at a few universities, but I see it very much as a practical skill, and therefore not overly academic. And for the academic parts of the course, because of course I'm delivering it as my business, not just as me as an individual, I get academics in. So keep it nice and simple. I'll do the theory. I'll show them the hands-on what it's like to mediate. But when it comes to the academic side, I've got some great faculty members who will deal with that for me. But I think it does, even here, it does skew people's view of you. If I'm constantly sort of talking about training mediators, and even private practice or in universities or whatever, people start to pigeonhole me as a trainer. I'm not a mediator anymore. Where of course I see myself very much as both. And I do think you're right. I think when you're involved in training, if you're the right mindset, it makes you better at what your original job is, because you're constantly learning and constantly refining. And if I look back at how I mediate now compared to how I mediated when I first started, and before I did the training, it's completely different. To the point where I often say to students, the course I'm teaching you is similar to passing your driving test. You have to do it this way in order to get the accreditation. But if you were to watch me in a mediation, I don't do a lot of this stuff. Because actually I've now developed my own way of doing it, and I wouldn't pass my driving test if I was doing it tomorrow, and it's the same sort of principle.
Yeah, but you've developed your way of doing things with the benefit of the knowledge of how it's supposed to be done, and so you have a sense of why you're doing it differently, and it's the wisdom of years of practice, I guess.
Yeah, I suppose. Stop reminding me of my age. Okay, now a fun question. I've had a bit of a theme going through some of these podcasts, where I've asked people what the most embarrassing situation they found themselves in a sort of arbitration ADR environment. So it could be at a conference or an event or something like that. And I've shared a couple of mine as well. So I'm going to ask you today to start that ball rolling again. So can you think of anything very embarrassing that's happened to you? Oh, you can. That's good.
I can. The question is, which one can I share a podcast?
Yeah, you've got to keep it clean. Keep it clean.
Exactly. Okay, yeah. So there was a number of years ago, I think maybe 12 years ago, not quite 15. I was a junior lawyer. I was in London, and I was attending this conference. And at the time, I didn't get many chances to go to conferences because they were quite expensive. And so I was really excited to attend this conference, which was hosted by one of the London universities. And so I put on my best suit, which was this second-hand, Italian suit that I loved so much. It looked great, but it was it's an old suit. And I go there, and at the end of the very first session, the first coffee break, I'm the first person to walk out, and I'm discussing with Johnny Villa on, I can't remember what we're talking about, but as I talk to him, I drop my name tag, and I lean forward to pick it up, and I hear a very loud crack, and basically I torn a massive hole in my trousers, in the back of my trousers, but like 8 inches, something absolutely massive. It was so loud that I suspect that Johnny Villa actually heard it, but was very nice about it. So what I did is I started to walk backwards with Johnny Villa like facing me, and I was facing him, and I was walking backwards to make sure that nobody could see this massive crack in my trousers. And to let people get out of this big conference room, I lean against the wall and continue the discussion. And then I'm thinking, okay, I've got to make this discussion last a long time because I need everybody to finish their coffee, go back into the conference room before I can escape. And so I keep it going for forever. And finally, everybody goes back in, and I excuse myself, and I leave the conference venue, and I'm thinking, okay, I've paid for this conference. It's a lot of money for a young lawyer, and I really don't want to miss it. But I've got this big, big tear in my trousers. So what I do is I go to a dry cleaner at Barbican, a very, very small dry cleaner. I walk in and I tell the guy, okay, you've got to fix my pants. And he tells me, we don't do alterations, we don't do alterations. And I tell him, he says, you have to do it. It's an emergency. So I take off my pants in his shop, at Barbican. I give him my pants, and I'm standing there, in my underwear with my suit jacket, my tie, etc. And the guy is trying to stitch my trousers back together. And of course, a customer walks in at that time, an old lady who looks at me in my boxer shorts and my tie, wondering what the hell is going on. And so the dry cleaner continues his job. And I think when he said we don't do alterations, he meant we don't know how to do alterations. So he gives me back my trousers, and they look like a Frankenstein type of, scarf. So I put them back on. I thank him profusely. I pay him, and I go back to the conference room because I did not want to miss the rest of the conference. So I'm sitting in this conference with this, gigantic, scar on the back of my pants. But I was very proud of myself because, I thought I had to make a choice between between not learning about arbitration and, potentially taking the risk of making a fool of myself. And I think I made the right choice.
Yeah, I think you did. And I think history shows that you did, because it could have been very different if you'd not done that. Oh, that's brilliant. That's brilliant. I mean, felt very sorry for you, but that's a good story. I like that one. So my one then, I think, in response to that, to try and make it similar, is similar but opposite, and not far from there actually. When I was first at the Chartered Institute of Arbitrators, we were based on Angel Gate, which is not far from Barbican, and the back entrance is Goswell Road, which leads down to Barbican, so really quite close to where you were at the time. And I used to go swimming at City University swimming pool, and I'd go swimming, and then I'd leave my trunks on the radiator in the office so they'd dry, and then I'd use them again the next day or whatever. And then one day I went there, and they had the old-fashioned cubicles get changed in, so I got completely undressed so I could put my trunks on. Started putting my trunks on, and my foot wouldn't go through the leg on either of my legs. And basically I'm standing there falling over in this cubicle, and Val Seymour, who was the Director General's secretary, had sewn up my trunks overnight because she was sick of me leaving them on the radiator to dry. She'd sewn them up so I couldn't get my legs in. So yeah, that was quite embarrassing. It was embarrassing because no one could see me, thankfully, because I was naked. But it was embarrassing because when I got back to work, everyone knew, so everyone was waiting for me to come back and ask me how my swim had been. But
it's pretty good sewing skills. Maybe I could have used his help with my trousers.
Well, that's it. If you'd have known us at the time, you could have nipped up City Road or Goswell Road, and Val could have done them for you. Lovely. You mentioned differences between civil law and common law. What do you see as the main differences between the two in an environment of arbitration, like acting as advocates, as students, as academics, arbitrators, mediators, whatever it might be? What are the main sort of key differences that you see?
I think there's a lot of differences. And again, by way of background, I think I've got my bottom in between two seats because I'm French originally. I'm American now as well. And I studied law in France, but I also studied law in England, in America. And I spend more time practicing in a common law jurisdiction. So I don't quite feel like a civil law lawyer, but I'm not a common law lawyer either. So I'm a bit in between. And I think that ultimately the big difference is a difference of approach as to how people see the law and how they use it. And I think
Mm.
at the risk of oversimplifying, in the common law world, people look at things very practically and are a lot less theoretical. To give you a parallel, because I think it's a cultural difference between continental Europe and England and America. I think it's a very big cultural difference that applies beyond the law. I got a 6-year-old son who's learning to read and write. And so during the week, he's learning that in an American school system. And on the weekend, he's doing that at a French school in French. And so during the week, he's learning how to use language in a very functional sort of a practice-oriented way. He's learning how to read and write so that he can extract meaning from text, so that he can convey meaning, so he can tell stories and explain the stories. And when he does the exact same, program, the first grade program in the French educational system on the weekend, what they're teaching him is the grammatical theory. So like, the different groups of verbs and like the Latin root and how you add a prefix and or whatever to the words. And so it's very top down in the continental European world. People are interested in theory and how things work, as opposed to the actual use of the language as a tool. And I think the same is true for the law. And there was a joke I said once at a conference. It's one of my favorite jokes. It's I'll tell it very quickly. It's this at the turn of the 20th century, you've got this American engineer that has come up with a fantastic invention. It's a new machine that does things that no machine has ever done before. And so he demonstrates how his machine works to a group of engineers from all over the world, and it's incredible. The machine works so well. It does incredible things that no machine had ever done before. So everybody's very impressed, except, of course, for the French engineer, who raises his hand and says, okay, so what? It's great. It works in practice, but does it work in theory? And which, of course, makes no sense. And I think it really captures a big difference between the two worlds that you see in legal practice and in arbitration in particular. Civil law lawyers tend to be very top down. When you look at their work product as an arbitrator, you look at pleadings, they tend to be incredibly structured. It's probably a remnant of the Roman law tradition. So it's very structured. Everything is very logically put and there's no repetition. And they tend to do that better than common law lawyers. But then the flip side of that coin is that common law lawyers, while they might repeat themselves a little bit, the structure may not be quite as beautiful, and it might not look like a Roman city, the blueprint of a Roman city. It's they go much deeper in the analysis of how the law applies to the facts. And I think it's a product of the fact that in the common law, you've got cases, you're working with cases that you're taught early on in university to distinguish based on very nuanced and precise facts. Whereas in the civil law world, you really learn in a top-down fashion, about the structure, about the logic, etc. So that's big differences. And I think younger students or younger practitioners are lucky because they're able to go and study in different jurisdictions and work in different places and hopefully learn the best of both worlds.
So I've got 2 questions left. Okay. So the first one, who do you admire the most in arbitration and why?
So I've got, I think, 3 idols, but one of whom is still practicing. So I'm not going to mention his name because it would be a bit awkward if I were to appear before him or vice versa. But the first one is Johnny Vida, who I mentioned before. And the reason why I admire him so much, sadly he passed away 2 years ago, is because, first of all, he was incredibly intelligent. He was a very, very fine legal mind. I remember at the LCIA, the secretariat, we would often have to write to him almost every day to ask him, in his capacity as vice president of the LCIA court, to make decisions in LCIA cases under the rules. And we would go to Johnny Vida when we really had complicated issues, when we thought there was really something at stake and we needed somebody to show, this infinite intellectual patience to really go beyond the appearances and think things through. And he was never disappointing. It was always coming back with great decisions. And so he had this very fine legal mind, but at the same time, he was incredibly humble and kind-hearted. He was somebody who, despite having achieved everything you can achieve in the world of arbitration, he had remained very, very kind, very warm, and he was taking a genuine interest in the people he was working with. You could be a receptionist or a QC at the time, and he would show the same level of respect. And so that's something, I try to aspire to, of course, at my level, but I often think to myself, what would Johnny Video do in this case?
Yeah, I actually really love that in people who have made it. And you see this a lot, from someone from humble beginnings. I've managed to mix with lords and ladies and plenty of sirs and judges and so on. And actually, the further up the tree they get, the more pleasant and polite and sort of respectful they always seem to have been to people in different roles and positions. To the point where if someone's not like that, it's quite a surprise. And it really stands out. And I think the general population who don't mix with those sorts of people don't really realize that. They've got preconceived ideas of what people are like who have maybe made it to the top in a legal profession or in terms of being knighted or put in the House of Lords or something. But they tend to be very nice, very pleasant people.
Right, and you're entirely right. And so the second person I really admire a lot was my boss at the LCIA, Adrian Winstanley. OBE was the longtime registrar and director general of the LCIA, and just like Johnny Vider, he had a brain the size of a planet. He was incredibly intelligent. He is incredibly intelligent, and at the same time, he had this capacity to really value the opinion of everybody in the team, from the receptionist all the way up to the senior lawyers. And that's something I've learned from him, to try to extract every drop of talent that you have in your team, and to do that, you've got to not have a chip on your shoulder, right? You need to accept that somebody who's brand new might have better ideas than you on something, and you should be happy about that, and you should leverage that to your own benefit. But also, what he was able to do, and the reason he had such an influence on my career is because he gave people opportunities to grow. So he would give you responsibilities in a way that was reasonable and measured, but it would give you an opportunity to do more, to take on more, and to develop. And I am immensely grateful. And one anecdote I will say is so Adrian Winstanley had become a lawyer fairly late in his career. I think he became a solicitor in his 40s, if I'm not mistaken. He trained at Clifford Chance. And before that, he had all sorts of experiences in business in particular, including abroad. And so that guy was not, he had not practiced for many years. And yet, when he was talking at a meeting of the LCIA in front of all of these legends of arbitration, including Johnny Vida and others, people would shut up and listen. And the respect that he would command was quite impressive. And I think the reason why people at the top of the arbitration game would listen to him so much is because of the quality of his work. He's just so intelligent, and that people would genuinely want to know what does Adrian think, tell us. And I thought this was forcing the respect of the greatest in our field was really something impressive.
And I mean, he's now a colleague of mine at Arbitral International, and maybe one day I'll get him to do this show as well.
It'd be nice.
Hopefully, fingers crossed. I'll have to ask him first. But what he had as well, and I think it's that important distinction. If you're outside of the organization, he had that gravitas about him that made you wary. So I'd bump into him at the IDRC in the lift sometimes. He wouldn't have had a clue who I was, but I knew who he was, and I would often feel quite intimidated, sort of just knowing that was him as it was coming out the lift. And I think it's interesting when you hear from people who worked with people who you were potentially in awe of in that way, that actually they were really nice and they brought the best out of you, and you know, they helped you along in your career, because that's not necessarily what you see from the other side of the fence. Yeah,
That's
so I
true.
think that's good distinction. Yeah, excellent. Okay, so final question. Is there anything you wish I'd asked you that I haven't?
Ah. I'm not sure. I mean, there's a question of the question that nobody asks me, and it's probably for the better, but I'm happy to answer it. Is as an arbitration lawyer, you know, what do you think of mediation? Because often we pit people, you know, against each other, and as an arbitration scholar, somebody who's decided to do a PhD in arbitration, to teach arbitration, I am absolutely convinced that mediation is an incredible mechanism for resolving disputes, and that very often clients would be well advised to try it, to just try it because it works. And I've seen it as in private practice, and it works so much better than in-house lawyers and practitioners, litigators in particular, really want to admit. It really works well. And a lot of disputes that end up in arbitration are actually disputes that could have been settled with a good mediator. Of course, you need somebody who knows what they're doing, but it does work. And in particular, when you use caucuses, you know, and when the mediator is able to talk to the parties separately and understand beyond, you know, their positions, their stated position, where their true interests are, and identify, you know, windows of opportunity for settlement. It just works. It does, and we shouldn't pit the two modes of dispute resolution against each other. I think it's really silly.
No, I think you're right. There's no reason to make some level of competition between them. They're both great in their own ways, and I'm often asked which one I prefer, and I can only answer in as much as I am a mediator, but I also run an arbitration business. So for me, I see equal value in them. I think it's interesting to consider things like MedArb is something that always comes up, and whether the same arbitrator should be the person who was previously the mediator, and people have got very strong views on things like that. Have you got a view on that?
I do actually. I think it's typically wrong for the mediator to then go ahead and act as an arbitrator if the mediator has had ex parte communications with each of the parties in the course of the mediation, because there, you know, what happens, of course, is the mediator will have been told information by one side which the other side will not know, and so you won't have an opportunity to rebut it if it's false information, or if you have good evidence to, you know, to at least question it. As a counsel, as somebody whose job is to represent parties in their disputes, I'm naturally uncomfortable with the idea of having a neutral in charge of making a decision. In my case, you know, making that decision on the basis partly of information which I don't know has been given to it. So I think it's a real issue. I think different people should be mediating and arbitrating. It's my view. But in any event, I think you really need skills, the right skills to be a mediator, to be an arbitrator. And I don't think that you know, a run-of-the-mill arbitrator who doesn't do mediation will do well as a mediator. It's you know, it's like in France, we like our, you know, if you go to a baker, it's not the same as a pastry chef. You know, it is you know, it is not the same profession.
No, I agree, and very good explanation there. I agree with everything you said there. I don't mind the concept of MedArb, but actually, right from the first time I ever heard of it, which was in about 96 or 97, was very much in the camp that you can't have the same person being both. And it tended to be, at the time, people who were not qualified as mediators but were arbitrators, who were, oh no, it's fine, I can wear two different hats. But it's not about wearing two different hats. It's about the perception from the parties. It's about someone being able to relax and give you information as a mediator that they would never want you to know if you were a decision maker. And therefore you've got less of a chance of settling at mediation, because you're not going to get the parties to open up to you as much as you want them to.
Right.
So just a final question that's just occurred to me on this topic as well. What do you think is the most important skill for a mediator to have? Is it communication, or is it expertise in the subject matter?
It's a tough one. I would naturally think the former, but at the same time, there are some highly technical disputes where, if you don't understand the facts effectively, so either the business or the product, the IP, for example, that one party claims was stolen by the other side, etc. If you don't understand the technical side of things, you'll struggle to really move the needle. But I would think that what matters the most is the capacity to foster enough confidence to be able to collect from the parties enough information to understand where the window of opportunity is located. And for that, you need to foster confidence. You need to be able to ask the right questions so maybe more the interpersonal skills rather than the technical ones.
Yeah.
But just like in arbitration, in a sense, for a long period of time until about maybe 2005 or 6, law firms thought that arbitration lawyers, there was no need to set up dedicated arbitration practices. You would be an energy lawyer and you would do litigation and arbitration, or construction lawyer. And then things changed over time, and now the vast majority of firms that do arbitration regularly have a dedicated practice, precisely because people have come to see that skills, in the process of arbitration are more important than industry knowledge when it comes to in-house lawyers purchasing legal services. And I remember conducting empirical research at Queen Mary University about 10 years ago, where we talked to in-house lawyers in energy, construction, and financial services, and telecom as well. And often in-house lawyers would tell us that on balance, they care more about whether the potential arbitration lawyer knows arbitration and is a good arbitration advocate, as opposed to an expert of the industry sector. The caveat is, they said, you need to understand the industry. That's a given. You need to have some understanding of the industry, but we don't necessarily want an expert in the industry. We can educate the lawyers. So what we need is the skills in the actual process. And I think the same applies to your question and mediation. I would say interpersonal skills and true mediation training, to knowing how mediation actually works. And it's probably more important than knowing the industry, but I don't know. That's my opinion.
Yeah, lovely. I share it. I'll let you have that one because I share your opinion. Great. Thanks, Remy. Can you give our listeners a good way to get in touch with you if anyone wants to get in touch with you?
Of course. I think the fastest way to get in touch with me is at my firm, so Hughes, Hubbard and Reed in Washington. I'm like all lawyers, always on my emails. If you write to me at Queen Mary University of London, I might take a few days to get back to you, to be honest. But so do reach out to me at my firm if you want to talk about anything we discussed today.
Excellent. I'm sure people will. So thank you very much, Remy Gerbay, for being my guest today. And
thanks
I'll
a lot.
see you next time on No Dispute in That. Thank you.
Thank you so much. Goodbye.
That's all for today from No Disputing That. I hope our discussions have helped you to learn more about the world of mediation and arbitration. As we come to a close, I want to thank you for listening in and thank my special guests for their insightful advice and ideas. If you have any questions or feedback, please feel free to leave me a voice message and you might even be featured on a future episode. Until next time, this is me, Gregory Hunt, signing off. Thank you so much for joining me and have a wonderful day.